Our firm, Wagner Sidlowski, is a boutique litigation law firm in downtown Toronto. We are presenting this video/podcast on capacity and insane delusions. Let's join Joanna and Charles as they discuss Justice Cullity's analysis of insane delusions in Banton versus Banton. Joanna, are you ready for the podcast?
Sure.
Have you completed the research that I asked you to do on capacity and delusions for the paper I'm presenting?
I have.
Did you run across the case of Banton versus Banton?
Of course.
I have a problem with that case and how it treats insane delusions. Can you give me a hand with it?
Sure.
Okay, let's just go through the facts quickly. 89-year-old George Banton meets 31-year-old Muna, who's a waitress in the nursing home. She persuades them that they're in love. She persuades George to get married. She persuades him to go to a lawyer and sign a will that disinherits his children. In your research, did you come across what the definition of insane delusion was?
I did. Actually, Justice Cullity outlines a two-pronged test for insane delusion in Banton versus Banton. So the first part of the test is a belief in facts that no rational person could believe. And the second prong of the test is that that belief, or that insane delusion, has an effect on the disposition that the testator is making.
Right. Let's focus on the first prong of the test, because that's what I'm having difficulty with.
Okay.
Did you come across any case law that dealt with the first prong of the test?
There were some cases that deals with the first half of the test. So, for example, there was one case where a father decides to disinherit his son on the mistaken belief that the son isn't actually his biological child. But that was only a mistaken belief in reality, as opposed to an insane delusion, so the will was still held to be valid.
Now that case is appropriate, because that was a reasonable conclusion to come to. It was a mistake, but it was a reasonable conclusion. And that's the problem I have with the Banton case. Do you have a copy of the case here with you?
I do.
Here it is. This is what George believed, and this was one of the reasons he disinherited his children. Let me first paint the scenario. It's the day after they're married. George and Muna has stayed overnight at Muna's place. They come back to Leisure World, and the children are waiting for them in the room. They're frantic. They don't know where their father has been. Victor, George's son, takes his dad and physically removes him from the room. This is what George thinks about that incident. I have been subjected to instances of abuse by my sons. The day after my marriage to Muna, my son Victor pushed me violently through a door at Lifestyle's retirement home. As a result, my left hand was bruised and I could not use it for 3 weeks. This is what Justice Cullity says about George's view of that incident. I accept the evidence of Victor, Joan, and George Jr. that there was no violence. If any bruising occurred as a result of the incident, and I'm not satisfied on the balance of probabilities that it did, I have no doubt that it was accidental. It seems as if Justice Cullity is taking a view of this as an objective test. Was there a mistake, or was there not a mistake? But that's not the test for insane delusions. Do you know what else bothers me about this case?
What's that?
Well, George did not have the capacity to make a will. He had the capacity to marry. Under the Succession Law Reform Act, Section 16, when you marry somebody, you revoke all previous wills. So this financial predator was able to benefit under the will. Now, did you do any research on capacity to marry?
I actually did. I read about that in Kim Whaley's book.
That's an excellent book. I want you to footnote it in the paper. Now, I'll have you know that at the end of the day, Justice Cullity solved the problem about Muna and her inheritance. But that's something for another blog, another time. My name is Charles Wagner. I'm a partner at Wagner Sidlowski and a certified specialist with the Law Society of Upper Canada. Joanna Lindenberg, my associate, and I would want every viewer to know that this is not meant as legal advice. The purpose of this vignette was to provide the listener and the viewer with an idea of how lawyers might address the complicated issues of capacity and insane delusions. I'm going to repeat to you the advice that I provide to many of the junior lawyers who call me for advice, or even the counsel from out of the jurisdiction when they have issues dealing with estates and trusts. There's no replacement for retaining a competent lawyer to review the facts specific to your situation and to do their own research in the law. My name is Charles Wagner.